As you might expect, there are a number of federal constitutional limitations on the California legislature and lawmaking. So, when drafting and considering bills in the California legislature, bill drafters and legislators themselves need to be aware of some of those federal limitations on state legislatures that are imposed by the federal Constitution. In general, the United States Constitution is generally viewed by legal commentators as granting powers to the U.S. Congress, while the California Constitution is viewed as simply providing limitations on the legislative power. I note the 10th Amendment to the federal Constitution that provides that all powers not delegated to the United States nor prohibited to the states are reserved to the states. Perhaps the most important limitation on state legislatures is found in Article 6 of the U.S. Constitution. It provides the following: This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. This, of course, is the Federal Supremacy Clause. In Article 1, Section 8 of the Federal Constitution, it specifies the powers reserved to Congress. As a result, this limitation obviously limits the power of the states to enact laws in those particular areas that are reserved to the federal government, such as the regulation of interstate commerce, bankruptcy, and immigration. Article 4 of the federal Constitution requires each state to give full faith and credit to the laws and judicial proceedings of those of other states. In addition, Article 4 requires citizens of each state to have all the privileges and immunities of the citizens of other states. The U.S. Constitution also contains a number of express limitations on state sovereignty. These are found in Article 1, Section 10, such as the prohibitions on states from entering into treaties, granting letters of marque and reprisal, coining of money, providing bills of credit, passing any laws of attainder, ex post facto laws, or laws impairing the obligations of contracts, or in granting any titles of nobility. Finally, in Article 1, Section 4 of the Federal Constitution, it limits state control of elections for the United States Senate and the United States House of Representatives. And basically, Article 1, Section 4 requires that state legislation is subject to regulations that are passed by the Congress.